So once again, good afternoon, ladies and gentlemen. I am Christopher Nicholas, Client Relationship Manager of SPEAKRIGHT CONSULTANCY SDN BHD. I would love to take this opportunity to thank all of you here for your effort to be here on a very important yet critical topic, which is anti-bribery at the workplace and debt recovery. Now, the reason why we are here having this forum is to bring awareness about the importance of why workplace should be free of corruption and how to recover bad debt. The second reason is SPEAKRIGHT Consultancy is providing legal training and also services in the area of corporate. With me today is Mr. Gurmeet Singh, our moderator for today's forum, my senior manager, Ms. Crystal Lee, which will be handling the closing part, Mr. Xavier and Mr. Kenneth. I would like to introduce our moderator, Mr. Gurmeet Singh. He is SPEAKRIGHT Consultancy Exclusive Trainer. His area of expertise is leadership, communication, and collaboration. He is also a member of Toastmaster and represented Malaysia to an international speaking contest held in Canada. We are very fortunate to have Mr. Gurmeet to moderate this forum, and without consuming any more time, I will pass this to Mr. Gurmeet Singh. Back to you, Mr. Gurmeet.
All right, thank you very much, Christopher, for that wonderful introduction. My friends, welcome to the Corporate Legal Forum. So today we are privileged to talk about, or rather focus on, two very important topics. The first topic is your workplace corruption free? And the second topic, debt recovery. Now, before we go into the topic itself and before I introduce the speaker, let me first introduce the program, the forum. All right, so this forum is run for the purpose of helping our clients be familiar of the law in running their day-to-day business by being aware of legal aspects of running a department and business. The MACC 17A amendment of June 2020 has a big impact on the senior management of a company of which many may not be aware of, especially when unethical business practices may be present. Hence, this session is to create that awareness with the HR and all stakeholders. In addition, many companies during this time may be struggling at collecting debt, and hence we are here to share some preventive strategies to ensure your collection is back on track. Now, moving forward, SPEAKRIGHT will be suggesting some topics of interest such as immigration law, contract management, employment-related issues that you may be keen to train your employees on, relevant areas of the law that you would like to help run their departments according to law, and to avoid any breaches or suits in the future. We are proud to partner with Mr. Xavier and Mr. Kenneth from Nazrin Kuok Putucherry and Tan Advocates and Solicitors for this purpose, and we are certain they too will be a good point of reference for all your legal needs moving forward. Now, before I start introducing the first speaker, there are three important things to take note. The first one, you may type out your questions while the speaker is speaking. So you don't have to wait until the speaker is done speaking to type out your questions. You may type it out in the chat box while the speaker is speaking. However, the speaker will only answer them during the Q&A session. So once again, feel free to type out at any point of time as the speaker is speaking. Now, the second thing to take note of, please keep your questions to a corporate standpoint rather than a political one, because at the end of the day, this is a corporate legal forum. And finally, to encourage our speakers, let's say you have something you liked, something you heard from the speakers that were very interesting. You can immediately use the reaction button and put a thumbs up like I'm doing right now, or give them a clap to encourage them. All right, so with that note, before I introduce our first speaker, Can I ask you guys a question? The question is this: are you ready for the corporate legal forum? If you are ready, type in yes into the chat box. I will wait for the yeses to come in. All right, a lot of yeses are coming in already. Okay, wonderful. Right, yep, a lot of yes. Thank you. Let me start with our first speaker, which is Joachim Francis Xavier. Now, Mr. Xavier graduated with a LLB Honours London and holds a certificate of legal practice. He began his legal practice in one of the largest and oldest firms in the country, Messrs. Choi and Company, plus Chiang and Arif, before moving on to this firm. He practices both civil and criminal litigation. His clients include individuals and corporate entities, both local and foreign. Mr. Xavier is also regularly engaged by foreign law firms who have no presence in Malaysia. On the criminal practice front in 2018 and 2019, Mr. Xavier has been much sought after for advice on disclosure obligations under the Malaysian Anti-Corruption Act 2009, Witness Protection Act 2009, and the Whistleblower Protection Act 2010. In addition, he also advises and represents clients in matters concerning intellectual property, land, tort, and contractual disputes. Mr. Xavier has extensive experience dealings with authorities such as the Royal Malaysian Police, Royal Malaysian Customs, Malaysian Anti-Corruption Commission, Inland Revenue Board, Immigration Department of Malaysia, and the Department of Environment, just to name a few. It is interesting to learn that Mr. Xavier is regularly sought after by clients for training on law and procedure. Among the topics which he has trained on include dawn raid response, corporate corruption liability, and anti-money laundering avoidance. Apart from this, Mr. Xavier also advises and represents clients in matters relating to criminal liability, which are corporate and individual, regulatory enforcement, corruption offences, money laundering offences, and other white-collar crimes. He also regularly represents foreign clients pertaining to immigration offences. And just to let you guys know, Mr. Xavier is also a very great speaker because he was a charter member of the Bayan Baru Toastmasters Club in 1996. He went on to earn one of the most coveted titles in Toastmasters, which is called the Distinguished Toastmaster title. So without further ado, I would like you to use the reaction button and give Mr. Xavier a round of applause. All right, with that note, Mr. Xavier, the floor is all yours.
Thank you, Gurmeet. Thank you for that very generous introduction. Okay, let me just make sure I got the slide and notes out. Okay, so welcome everybody to this program this afternoon. I hope you've had a good lunch. I want to thank SpeakRight for providing me with this opportunity to speak on this topic. Clearly, it's a very timely topic given the events of the last few days and generally the direction that this country is moving in. What is abundantly clear is that it's no longer business as usual for companies in Malaysia. We know, I'm sure you're aware that individuals have always been liable for corruption if they commit a corrupt act. But since the 1st of June, MACC has decided that they're going to up the ante and make companies as well liable for corruption. And this has got a lot of companies, particularly the directors and top managers of companies, worried about whether the affairs in their companies, the transactions that are taking place in these companies, would they pass the scrutiny of the Corruption Act as amended from 1st of June. And just like SpeakRight, our firm has received so many inquiries about this, and that is why it's very timely that this session is organized. And it's particularly important for managers to be aware of this, directors to be aware of this, for the simple reason that it will be incumbent on the top management to recognize incidences of corruption that may be occurring in the companies, in the transactions of the companies. From our experience, because of the lack of knowledge of what is corruption and the scope of corruption, often transactions are done in a way that is caught under the Corruption Act but not detected by top management. And the only time it gets detected is when the authorities come knocking on the doors of those companies. At that point, it becomes utterly embarrassing for the company. It becomes a reputational issue, and worse, we've seen companies suffer losses, tangible financial losses, because that transaction was detected too late. And so this session will give you, to some extent, an understanding of what is corruption and how to be sensitive to it so that you're able to detect it within the ranks of your company and its transactions. Bearing in mind also that it's very important to know that there is a much unknown provision in the MACC Act, which is Section 25, which says that when one becomes aware of a corruption transaction, he or she is under a legal duty to report it. No longer is it an option for one to decide, all right, you know, that's my friend or that's my employee, so I'm not going to report it. Today, as it stands, the law, if that transaction is not reported, the one who had knowledge of it but did not commit it, who had knowledge of it, also commits a crime. Now, my dear friends, with that as the background, perhaps we want to quickly look at what are the topics that we will be covering today, the flow of today's webinar. I'm at introduction now, and in order for you to fully apprehend what is corruption in the context of corporate liability, we will need to know what is gratification. The local term for gratification is bribe. That's the term Malaysians usually use. They call it bribe. The legal term is gratification. We'll talk about that. We'll talk very, very lightly about individual liability because that's common, and we saw our ex-Prime Minister being convicted in court yesterday. That's individual liability as a person. But what's important and what's relevant to you as managers and directors of your companies is corporate liability. How a company, an entity, a Sdn Bhd, a partnership, a sole proprietor could be liable under the amended MACC Act. Finally, we look at the defenses, what companies can do to avoid being put in an embarrassing situation of having to answer for corruption committed by the members of its organization. This will be the flow for today. Now, I want to very quickly do a quiz here, and if you can use the chat function here, and the groupmate will help me read out the answers. What do you think is Malaysia's score out of 100 marks for its efforts to stamp out corruption? So there's 1 being very low or almost a fail, and 100 being excellent. What do you think is our score for our efforts to stamp out corruption?
Okay, I think they're still typing out. All right, out of 1 to 100, what's the score? Feel free to type out your answers in the chat box.
Take a guess. Do you think we'll score 75 out of 100, maybe 25 out of 100, maybe 10 out of 100? What do you think? Just take a guess.
Okay, Yong Yo Ming said it's about 50, if I'm not mistaken, based on last year's CPI.
How much was that? Sorry again, Gurmeet?
50.
50, okay.
Yeah.
Let's
So
try another
yawning.
question. Sorry, do you have another answer, Gurmeet?
No, only one.
Okay. What do you think we are ranked in the world in terms of being corruption free? One being a country that is totally free of corruption and 180 being the most corrupt country. Where do you think we stand, Malaysia? I'll tell you it's not number one because Denmark is sitting there.
Michael said 100.
Okay, 100 is not too bad. It was just past the midpoint, right? Okay, I'll give you the answers for that quiz. Now, in terms of rank, we are ranked 51 out of 180 countries. So actually not too bad, because if the midpoint is 90, we're actually doing not too bad. Most Malaysians would disagree, but that's the global rank. In terms of score, we are 53. So out of 100, we are 53. We're slightly more than the average country. So not too bad. We are all right. Although within the country might feel it's quite bad, at a global level, we are an averagely corrupt country. All right. We know that MACC has become very active in the last few years. You see almost every day corruption offences being reported in the press. For a period of just 4 years, 2014 to 2018, we had 900 investigation papers, over 700 old people arrested. And you will see now, though, it's no longer just the small fries they go after the big fries. From what we understand and my experience with MACC and all the officers, as long as there's a complaint, they will investigate. Whether small or big, MACC will investigate. And that's been the experience that we've seen with our clients. Now, right from the start, let's be very clear about what constitutes gratification. And this is important. Most Malaysians and most of the people that I talk to think that the only way you can offer a bribe to someone is by way of money, all right? But the law is far wider than that. Any of these boxes that I put here is a gratification in law. Offering someone a position so that he will do you a favor, that could be also termed as a gratification instead of money. It could be a discount. It could even just be a promise. And this is important to note. A corruption doesn't occur only when money is transacted. A corruption can occur if you offered, say, a public official a promise to do something for him if he would give you that contract, if he would give your company that contract. The mere promise already constitutes a corruption offense. So it's very wide, and often people are caught by surprise. They will say, Xavier, but I never offered any money, and I never took any money. But as the facts pan out, it turns out they offered a favor or a promise or a position in the corporate company to that public official. So gratification is very wide. All right, we'll use the term gratification so that you get used to it as we go along. Okay. Now, which brings us to the main area: who can be liable for a corruption offense? Now, we know individuals can be liable, that's clear. But as I said, as of 1st June, companies can also be liable for corruption offense. And this is where you got to listen very carefully how a company can be liable under the MACC Act, Section 70A. Now, for the individual liability, these are the common offenses. We have Section 16, which is the offense of soliciting, which means asking, accepting, or giving a gratification. It's the most common corruption offense in the country. Section 21 is the second most common, which is the bribery of an officer of a public body. So if you deal with the customs department and you offer a bribe to the customs officer to clear your goods from the clearinghouse, that's an offense under Section 21. So this is the gratification. So you'll see that it's more than just money. And we were coming to the point about who can be liable for corruption offense. Individual, we know. And now we're talking about some of the offenses which an individual may be liable for. And we looked at, these are the top 4 offenses: giving bribes, taking bribes, offering a bribe to a public body. And interestingly, Section 23, which you want to be concerned about, is using an office or position for gratification. So if you're sitting in top management position and if that is used to obtain or to give a bribe, that will constitute an offense under Section 23. And of course, Section 18, the offense of deceiving a principal. And this is when the layman example is making a false claim. So if one makes a false claim in a company, that individual commits a corruption offenses. So these are offenses common to individuals. Now we come to the latest offense, which is corporate liability. And this is Section 17A. And I put here the wordings that is found in the statute. And you will see, of course, that the wordings are very verbose, all right? And I don't expect you to understand it, and that's why people engage us to interpret this. Section 17A makes it an offense for a company to be involved in a corruption activities. But let me break it down to you in terms of what it means in layman terms. If you were to really break it down, it means this: a company can be liable for a corruption act of someone in the company, even if it was to benefit the company. All right, so this really means that an employee or a director of the company offers a bribe to a third party outside the company for the purposes of obtaining a benefit for the company. When that happens, the company becomes liable for a corruption offense. The director, the manager who offered that will also be liable. The person who received the gratification will also be liable under the new MACC Act. Now let me illustrate this for you. I know this is a little daunting for the first time. Now, the Act says that the person who commits the act must be an associated person to the company. Now, who can be an associated person? Who does the law define as an associated person? You have here the director, you have the partner, you have an employee can be an associated person to the company. And get this, a person who performs services for or on behalf of the company, AKA an agent, all right? Now that really means, when you look at this, everyone in the company is an associated person of the company. And if any one of those individuals were to go out there and commit a corrupt act to benefit the company, not only that associate person gets into trouble, the company also gets into trouble. Previously, it was only the individual who got in trouble, not the company. All right, so it's very important that managers and directors keep a close track of their employees and their agents, external agents. For example, foreign worker agencies. A lot of companies deal with foreign worker agencies, and corruption is very rife in the foreign worker recruitment industry. Now, if an employee deals with that agency and the agency deals corruptly with the immigration officer, the company gets into trouble for that act. Here's an illustration. Here's Mr. A. He's a business development director of company XYZ, and he's tasked to bring in business for the company. A very enthusiastic man, very resourceful, and he goes all out to make sure that the company meets its numbers for the year. And then you have Miss B. Miss B is the procurement manager of company CDE, a separate company. Mr. A would like to obtain the contract which company CDE is offering, and so he makes a bid for it. All right, and he submits his proposal to Miss B, the procurement manager, and says, my company, we can do it all. Whatever you want, we can do it. Here's the proposal. Now, but he doesn't stop there. Apart from the proposal, he on the side offers a gratification to Miss B. Of course, this is not done over the table. In Malaysian parlance, it's done under the table. So imagine he provides a gratification. Nobody knows, only Miss B knows, and of course, Mr. A knows. Why is Mr. A doing this? Because he wants his company to benefit. He wants his company to get the contract. Miss B is very happy with the gratification, signs the contract, and awards it to company XYZ. Company XYZ is happy, Mr. A is happy, and so is Miss B. Now, very quickly, I'm going to ask you this question. This is a very simple scenario. Who do you think is liable for corruption here? Let's see it in the chat. Any ideas who will be liable for corruption here? A, yes, of course. A would clearly be liable for offering a bribe. Yes, who else?
There's a lot of A and B.
B, yes. Miss B, clearly for taking a bribe. Yes, and I see, Norain, you say XYZ. Yes. XYZ, the company XYZ would also be liable for corruption. Clearly, that is the case simply because A offered the bribe, Miss B took the bribe, and XYZ, the company, would also be liable because A is an associated person of the company. He is the business development director and employee. Now, if that's what corporate liability is about, then companies have to be very careful. They have to keep track of the individuals in their company. How are they transacting business? In our experience, sometimes the owners are not aware of what's happening within the ranks because the owners have multiple businesses and they are flying here and they're overseas and they're attending meetings. They may not be aware that the company may be transacting through their ranks in a way that is corrupt. And only if the employees and the upper management are trained to avoid this, are trained to recognize a corruption activity and are trained to skillfully avoid corruption while without losing business, this is the company that will survive in the new Malaysia. All right. Now, defenses. There are two types, individuals and the defenses for commercial organizations like a company. Now, for individuals, it's very clear. The only defense you have is, I did not give. And I assume that you did not give, that would be your defense. Or I did not take. And this one too, I had reported the offense. So here, this is my dilemma with HR managers. Often I get calls by HR managers because, you know, the first thing a disciplinary issue occurs in a company, the HR managers are notified. HR managers then come to know that a certain employee has been transacting in a corrupt way. Then they ask us for advice. What should I do? I tell them you have to report it under Section 25. And they go crazy. They say, what kind of advice is that? And we find that HR managers often would prefer to let an employee go and have the matter hushed up. I tell the HR managers, you will be committing a criminal offense if you did that. Not anymore can HR managers allow matters of corruption to slip their fingers at their own peril. So it's very important that these are recognized, and it's quite surprising that many do not know this. For commercial organization, the key word here is adequate procedures. The law says a company can escape liability if it puts in place adequate procedures. Now you'll be wondering, what is this adequate procedures and what are they for? Now, surprisingly, we looked at the Act and adequate procedure is not defined under the Act, but MACC had provided some guidance about what adequate procedures a company can put. Now, if you put these adequate procedures and if an employee still goes and corrupts and does a corrupt act, the company can say, look, we are not liable because we had done adequate procedures, but the employee still decided to act corruptly. And so it'd be a defense which could save the company much embarrassment. So let's look at some of the examples. Internal guidelines. So you would have internal SOPs, you would have guidelines of procurement, guidelines of dealing with vendors, guidelines of dealing with overseas parties, so on and so forth. Companies must document these internal guidelines and train their employees on these guidelines. And the guidelines must emphasize those ways and means to avoid corruption. Now, if you can show that, that's one defense a company can put up if it's accused of committing a corporate criminal liability. Staff training, as I've mentioned, staff have to be trained. They'll be trained that the company has zero tolerance to corruption, that there will be no negotiations about this. the company will have to prove that they have done training in order to be able to apply the defense in the event the company is investigated. Policy statements. So a company can issue a policy statement across the company, make sure that it goes down right to the last person and that it's repeated often. A policy statement should not be just on a plaque on the wall, but it must be spoken about, it must be communicated regularly, and the company must prove that it did that, so that if the company is accused that some of its employees had committed corruption, it can say, I had a policy statement that said this company will not tolerate corruption. If the company is able to prove that it did that, it escapes liability. Taglines on company materials are very simple. You know, you've got all kinds of taglines at the top of the letterheads, bottom letterhead. You could have that. We are zero tolerant to corruption, things like that. So these are some of the simple measures. There are a lot of measures that we could talk about, but we don't have time. But these are some of the measures. Reporting avenues. This is very effective. If a company puts out a statement to the employees and says, if you come across a corruption activity, this is the number to call, or this is the person to call. And that person could come and make a complaint of someone who is transacting in the company corruptly. And that person's identity and information is kept confidential. Bear in mind, any report made to MACC is kept confidential. The complainant's name is never revealed. So if a company can provide that avenue, that channel in which an individual can come and not fear for his or hers, not fear any repercussions, that's a wonderful defense a company can apply in the event the company is accused of a corporate corruption liability by its employees. Finally, vendor awareness or customer awareness. So companies may be right, they might be straightforward, but vendors may not be straightforward. Vendors will ask you, how do you want me to, I will issue you a blank invoice, you write whatever you want. How do you deal with such a situation? So there needs to be also awareness of the vendors. So we've done sessions where companies call in their vendors and we provide a training of sort or a session of sort which tell the vendors, this company does not tolerate corruption, don't even think about it, don't suggest it to any of its employees. Coming towards the end of my presentation, things are beginning to heat up in Malaysia insofar as corruption is considered even for individuals. But more recently, we've seen statements since June where MACC is saying they are beginning and it will go for companies who employees or directors commit corruption. As of now, there's not been a case yet because it's only June. I'm told there are investigations, but not yet a charge which is reported in the press. But what we can see, the Director of MACC is saying that it will not provide immunity to corporate sector that it used to have all these years. And if you look at the second one here, even though it's already has its own corruption prevention procedures, if they are not adequate, the keyword is adequate, the company would still be liable for corruption. So it's not just about putting any adequate procedure there, it must be an adequate procedure that meets the standard that the law requires. And it's only when the company meets that standard would it then be able to defend itself in the event it is accused of Section 17A offense. And clearly the more recent one is in July, more are expected to be charged under 17A. Many of these companies are unaware that they are even being investigated. They are transacting like usual. And being in this industry, we see it all the time. We see how recalcitrant and carelessly businesses are transacted. And they are being investigated and they're not even aware. The question then, my dear friends, is, has your company put in place sufficient, adequate procedures to defend itself in the event your organization, someone in your organization becomes wayward and engages in a corrupt act? That's a question only you can answer. Finally, my last slide, for those who fail to put in adequate procedures, for those who fail to take heed of the seriousness of what's happening in Malaysia today, this would be their dessert. If individuals commit an offense, you'll see Section 16 to 23, it is imprisonment up to 20 years a fine of 5 times the gratification value. So if that individual had given a bribe, had taken a bribe of 10,000, the fine is 50,000, or both. If it's a company, you see section 17A, the officers of a company could be imprisoned up to 20 years. And I'm talking about the directors, managers, the associated persons, or the owners of the company, or a fine of 10 times the gratification value. Clearly, the law sees with great seriousness this, and are asking the companies to get up to speed, get yourself prepared, and avoid corruption, so that it would be business as usual for you and your employees. With that, my dear friends, I thank you for your attention. I apologize for the slow display of the slides. I hope you were able to catch it, and I hope you've learned something from my session today. Thank you. Over to you, Gurmeet.
All right, thank you very much, Mr. Xavier, for that wonderful presentation. Now, let us give him a round of applause. So let's get the reaction button. Let's put the round of applause over there. Yeah, thank you very much, Mr. Xavier, for that wonderful presentation. I actually took a lot of notes while you were speaking because I found it very interesting. I think some of the things that were really interesting of what you said, first of all, was the fact that MACC is making companies liable for corruption. The second thing that was really interesting was this, although even a person has a legal duty to report corruption, so the fact that I know that corruption takes place, but if I buat tak tahu, if I ignore it, I'm in trouble and I'm liable for that. So that's very important to know, and I'll take note of that. Also, that was very interesting that you shared the statistics about Malaysia. It was the 51st out of 180 countries in terms of the rank for corruption, and 53 for score from 100. I also like that you shared this statement. You said this: a company can be liable for corruption act of someone in the company, even if it benefits the company. That was really profound. That was really shocking to me. And also this one, you said HR managers need to report corruptions rather than, cover everything up. And finally, the last part was really wonderful, where you shared how a company can escape liability by having internal guidelines, by staff training, by policy statements, taglines of the company, reporting avenues, and so on. So thank you very much, Mr. Xavier, for that wonderful presentation. Now, we would like to move into our Q&A session. So for this, oh, by the way, just to let you know, Mr. Xavier, Susie and Iwa says thank you for that session. All right, I'd like to move into our Q&A session. If you have any questions, please feel free to type into the chat box. If not, I will be asking a question very soon, but we would like you to ask questions. So let's take 10 seconds to type out your question in the chat box if you have a question for Mr. Xavier. All right, maybe I can start with one question first, Mr. Xavier.
Sure.
I like the fact that you mentioned corruption being rife in the foreign worker recruitment industry. Could you elaborate a little bit more, given that most of our participants here are from the HR background and may find this relevant? So the foreign worker recruitment part.
Yeah, I've handled a few of these, and this is the most unfortunate kind of corruption, because often the HR managers are quite clueless that this is happening, and then they get investigated and get into so much trouble, and I see the distress that they go through during that period of investigation. So there are two levels of corruption, Gurmeet, that could happen with the foreign worker industry. One is an overt one, another is a covert one. The overt one is when the HR officer or manager is aware that he's engaging in corruption. So the foreign worker manpower agency offers the HR manager or whoever is in the decision-making position a gratification, a bribe, in order to get the business. That's an overt, very obvious, right? And and they get into trouble. And it's very little defense when someone gets involved in something like that. But the one that's unfortunate is the covert one. It's when a company engages a manpower agency, for example, to go and obtain work permits, all right, foreign workers work permits, right, the PAS Lawatan Khas from the immigration department. And unknown to the HR managers, these agencies, and a good number of them, manpower agencies, offer a bribe to the immigration officers, all right, in order to obtain the work permits. The work permits may be genuine, may even be fake work permits issued by immigration. Can you imagine fake work permits issued by the immigration because the bribe was offered? When that gets discovered, then what happens is, quite clearly, if the foreign worker, the manpower agency is in trouble, but unfortunately, the human resources manager also gets into trouble because the manpower agency, wanting to protect himself, would say that I was instructed by my principal, by my client. And so they get caught in this whole thing. And that's why it's so important. We tell our clients over and over again, vet your manpower agency top to bottom. Do not deal with just the cheapest agency, because the cheapest agency may often be the most corrupt. You know, and so we say vet them, make sure that they're clean, because you could get in trouble for their acts under the 17A provision. This falls under the associated person who is an agent. All right, so he's not an employee but an agent, but the company takes a hit. So that's just to explain a bit on that.
All right, thank you very much. Mr. Xavier, there is a question in the chat box by Veronica. This is what she asks. At what point should a HR manager report if there could be bribe or kickoff received by employee? So once again, at what point should a HR manager report if there could be a bribe or kickoff received by an employee?
By the employee, yes, of course. Yes. Thank you, Veronica, for the question. It's an excellent question. The answer in law is reasonable suspicion. So as long as the HR manager has reasonable suspicion that a bribe was being received or being offered, the HR manager is under a duty of law to report. So bear in mind, that's different from actually knowing that it happened. If you know it happened, all the way you have to report. But the law is very strict. It doesn't say only when you're sure. When you have reasonable suspicion, you have to report it. And so if there's talk, if you've seen some emails going and you think this guy is receiving a bribe, you see that he's dealing with a particular agency or a vendor and he's becoming wealthier than his package would allow him, and you can trace some of those transactions, then you are under a duty to report that to the immigration, to the MACC, failing which the person who has knowledge of this would also be committing an offense under Section 25 of the MACC Act.
All right, thank you, Mr. Xavier, for answering the question. We have another question by Yong Yao Ming. The question goes like this: is a company, in brackets commercial organization, required to comply with the MACC Act 2009 or the MACC Act 2019, the amendment, or both?
Okay. Very good question. I can understand why the confusion. You have to study a bit of law to understand that, but I'll explain it as best I can. So the original act is the MACC 2009. All right, so you have, that's the full-on act, every provision is there, but it did not have 17A. Then Parliament passed the 2019 Act, which is merely the 17A provision. But what it does is, the 2019 Act incorporates the 17A into the 2009 Act. So to answer your question, you have to comply with both because it's one and the same. All right, 2019 Act introduces 17A and it says that 17A now is part of the 2009 Act. So if you look at the newer versions, the publications if you go to Popular, you buy the version that's after June 2020, you will see that 17A is in the 2009 Act itself. So yes, you have to comply with both.
Right, thank you. We have a question by Janet Lim. She says this: just wondering why HR manager needs to do the reporting of a corruption, or just anyone can came to know or has the suspicious over corruption. So basically, why do they need to report?
Yeah, fair question. No, it is not just the duty of the HR manager. The law doesn't specifically state the HR manager. That would be terrible if they did that, because all HR managers would be worried, sick about this. It says any persons who has knowledge of a reasonable suspicion of a corrupt act has to report it. So any person means it could be from the janitor to the owner of the company. Why I had mentioned HR managers, because often when I get inquiries my firm, it's from HR managers, because they are the ones who deal with the people in the company. They're the ones who normally will receive the first complaints. For larger companies, it will be department heads. They would receive the complaints first. And so whoever, any person has to, who's got knowledge has to report it. Now that doesn't mean that if two persons has come to know about it, he knows, I know, now I let him report. Does that mean that you escape? No, you don't. Whoever knows has to report. But if he has already reported, then you have an excuse for not reporting. But be sure that he reported. Then you can tell the MACC, saya tak buat laporan sebab rakan sekerja saya sudah buat laporan. Mengapa saya perlu buat lagi? So you got to be sure that it was made. So if you've seen the report and you know for a fact the person made, then you don't have to report.
Okay, she has a follow-up question to her question. So Janet asks this. So when we quote section 17A, we should quote MACC 2009 or MACC amendment 2018. I think she means 2019. Yeah.
Yeah. It's 17A of the MACC Act 2009. I know I've seen on the net there's so much confusion about this. People all say, so if you quote the 2019 Act, you have to put it in amendment. You have to put in the word amendment. But to be safe, the 2009 Act now has 17A in it. So you just quote the 2009 Act. Section 17A of the 2009 Act.
All right, thank you very much. With that note, let us give Mr. Xavier another round of applause through the reaction. All right, let's give him a round of applause. Thank you very much, Mr. Xavier, for that wonderful and enlightening sharing. Now, let me now move on to our next speaker, which is another wonderful gentleman, a very distinguished gentleman. So let me properly introduce this gentleman. I'd like to introduce our second speaker, Kenneth Kok. So Mr. Kenneth graduated with a LLB Honours London. He is an advocate and solicitor of the High Court of Malaya. His main area of practice is in corporate and commercial litigation, general civil litigation, industrial relations litigation, public interest litigation, and arbitration. And he has conducted trials in the subordinate courts and high court alike, and also hearing up to the federal court. He has special interest in contract management and debt recovery. Kenneth was a contributor to the drafting of Malaysian White Book by Sweet and Maxwell Asia, and he was named contributor in the Malaysian White Book for Civil Procedure published by Sweet and Maxwell Asia in 2013 and again in 2015. Kenneth was part of the legal team representing the Orang Asli who brought up an action against their former lawyers, who were also trustees of the trust that was set up for the benefit of the Orang Asli. He is also the project head of Legal Awareness Program of KL Bar Legal Aid Center, where it conducts the introduction and exit evaluations for pupils in chambers in relation to the mandatory legal aid service that they are required to serve. He has great passion for speaking and training in the area of negotiation and human relations skills. So before I call upon our second speaker, Kenneth, can we give him a rousing round of applause through the reaction button? Let's all put the round of applause reaction. All right, with that note, thank you, and over to you, Kenneth.
Thank you very much, Gurmit. Thank you very much, everybody, for being here. It's truly a pleasure. And so what I will be doing today is talking to you a little bit about debt recovery. There's a lot to be said about the issue of debt recovery. And I'm sure everybody here, every company here is involved in or would have some sort of debt. All right. And so whilst there's a lot to be spoken about this topic, I want to talk a little bit and zoom in a little bit on the boosting our chances of recovery and to avoid bad debts in the future. Now, I know that, and we have a lot of clients that come in and they say that the MCO COVID-19 situation has hit them very hard. I think it's hit the whole country very hard. I think it's hit the whole world very hard. The economy is bad. Until a vaccine comes up, people are saying that things are going to take a while to recover. And many companies are affected. Just 2 days ago, was it? No, not 2 days ago. Yesterday, there was an announcement where the moratorium for the banks, for the repayment of loans, which is also a debt, by the way, has been extended if you fall within a particular category. And so a lot of people here are very concerned, not only individuals, but companies alike. And so the reason this particular topic of debt recovery is important for us, I feel, is firstly that every company could be a debtor or a creditor. It's usually both at the same time. And so this issue does affect every company. Now, you might think to yourself, I have a lot of debts, and financially speaking, these debts are actually recorded as assets in your financials, which is great, except that it is actually useless until and unless it can be recovered. What good is a good, nice number on your financial statements if you can't actually recover it? And an unrecoverable debt would cause obvious cash flow issues. This would then affect viability of a business, and then obviously increments and bonuses. So if you're an employee of the company, this would definitely affect you. You're going to be, you would face disgruntled employees. You could face backlash. And so, you know, morale and all that is affected. And so that is a big deal. That's why effective measures have to be adopted by a company to increase the chances of recovering existing debt and also to avoid bad debts in the future. And so this is where training and education is required. Now, why do I say that training and education is required? This is because when we talk about the traditional or the typical way that I see a lot of companies approach this issue of debt recovery, so they could have, you know, a variety of debts. You could be a company where you engage in the sale and sale of maybe your products. Maybe you are engaging in the provision of services. You could be a company where the company is the debtor because you have engaged other companies' goods or services. And what I see a lot of times happening with companies is that when there's a debt, they go into this kind of a mode or this kind of a structure in order to recover that debt. It's a very reactive type of, it's a very reactive, a very adversarial, and a very mechanical type of approach. And what that is basically, okay, we have a debt, this is what we're going to do. There is requirement A, B, C, D. We are going to tick all the boxes, go through the motion, and let's see what we can get out of this debtor, out of this company, right? Now, what is this A, B, C, D? It could be engage a debt collector. It could be to send numerous statements of accounts to your debtors. It could be get a lawyer to issue a notice of demand or letter of demand, as they call it. And then after that, if they don't reply, you know, sue them in court. You know, bring them to court and then serve on them the summons. And so it's a very mechanical way and then leading up to judgment. But after that, what happens? You go through all of that hassle. And we find that creditors often end up with paper judgments and a long list of bad debts. Paper judgments are basically where judgments have been entered into against your debtor, but you're not actually recovering anything. So it looks good. It says that, hey, I've got, you know, however much amount that I am due and owing from my debtor, except that it is very rare that you are able to recover the full sum. And you then get a long list of bad debts and then having to write them off after a few years. Now, it is very common that companies are wound up in Malaysia. Companies are wound up in Malaysia because winding up petitions are filed all the time because they are unable to pay debts, right? The thing is, it is very common that once a company is wound up, especially if you're an unsecured creditor, you are looking at recovering approximately 10 to 15 cents to the dollar. That is if you are lucky, right? Many of the unsecured creditors actually end up with nothing. The other, and the other thing that we also need to take note of is that with the MCO, and this is a very recent and current development of the law, previously where you have, say you have a judgment against a debtor, you want to wind them up, and so what they do is you have to give them a statutory notice that is required by the law to say that, you know, if you don't pay up your debt, I'm going to proceed to wind you up. Previously, debtor companies had 21 days to respond to this notice. Now they have 6 months. So what happens, what that means is that where, as if the winding up process wasn't long enough, now it's just been made even longer. And until then, you are expending fees, you are spending legal fees, you are expending fees for liquidators to go in, you are expending fees for receivers and managers to go into a company, perhaps if it's a big enough company, and you're not seeing that money you know, realized at the end of the day. And it's just a long list of expenses. And of course, for a company to be able to write off debts is not so easy as well. You got to show that you have done whatever is necessary or reasonable to be done so that you are able to recover the debt. And if they don't pay up, okay, then we write it off. And by that time would have been expended, efforts, and more importantly, money as well has been expended. So we find a lot of companies, I've actually represented many companies who have to do it for the sake of doing it because they, you know, it is a requirement, and they end up throwing good money after bad. And so that is what we are trying to prevent here, you know, and this would be in the interest of all the companies here that have debts, which I'm sure most do. And so what is a good way of recovering existing debt? Okay, so I want to go now into the debts that you now have. People who owe you money, you are the creditor, you have sent them a few letters, you have sent them a few it could even be a lawyer letter. You may even have engaged debt collectors to come and get this done, and to no avail. So how do we then recover existing debt? And the first thing, what I would say is, where you do have debt, under the law, you have 6 years to file a suit in court. All right, so this is what we call a limitation period. And where you have a limitation period of 6 years, it must be from the date the debt was accrued. All right, so the moment, or from the point in time that you are owed that debt, you have 6 years to file a suit in court. But don't wait. In my experience, we have found that the sooner you take action, the sooner a company takes action, a creditor takes action, the higher chance of recovery from the debtor. I have actually had clients come and tell me, oh, many people are chasing the same debtor because they owe many people money. They also owe banks money. So I will sit back, I will relax, and I'll wait for somebody to wind up that company, and then I'll put in my proof of debt. What I would tell these clients, and if you are thinking that today, what I would say is, you could do that, except that all you end up with is a paper proof of that debt. Because realization of that debt is actually, the chances of realization is actually very slim. And so we find that, you know, you need to work, you need to move fast. And once the debt is accrued, you want to definitely take action to recover that debt, not more than a year if possible. Now, what that means is, for a company, structures and systems need to be put in place to track these debts and to take the necessary actions so that these debts can be recovered. So the next thing that you want to definitely do is to negotiate. Now, as opposed to litigate, you might be thinking, wait, but you're a lawyer. Wouldn't you be advising me to litigate as opposed to negotiate? Wouldn't you want to sue the debtor and get a judgment and things like that? My answer to that question is no, because at the end of the day, it doesn't necessarily serve your interest as the client or the creditor if you just litigate instead of negotiating. What we tend to find, especially in this time, is that collections are slow. With a lot of people, with a lot of companies, collections are slow. So what that means is they may need a little bit more time. And so negotiations can actually be done to your advantage. You might be thinking, no, I don't want to give them any more chance. I've given them so many chances already in the past. They keep saying they want to pay and then never pay. So I'm sick of it, I'm tired of it. Now, of course, if you have gone through enough of these negotiations, your 6 years is about to run out, please, by all means, engage a lawyer, file a suit. But if you still actually have time and your debtor is in a situation where they do want to pay, but they're not able to at that point in time, a negotiation could actually be in your benefit. Now, what do I mean by that? It can be mutually beneficial. Firstly, you want to be looking at putting or imposing, say, obviously it will be by way of installments. It could be a deferment of that payment, or it could also be a payment by way of installments. That's something to think about. But you also want to then impose, say, interest rates on the existing debt. And that is actually financially beneficial for you as a creditor company. The interest rates that are imposed, that would be up for the parties to decide. And recent cases in the courts have actually said that, you know, as long as parties have agreed to it, the courts actually uphold those interest rates. So this is actually a very good news for creditors, because previously people would have had to prove their loss and their damage before they are able to claim those interest rates. And so this development in the law is very new, and this is something that creditors can use to their advantage. Now, the other thing that you want to think about when you negotiate something like this, or a settlement of a debt, is to agree on future business deals. And this is how your company might be able to benefit. Because if, let's say, you are dealing with a debtor that you have had a long-standing business relationship with, put it this way: if I was a debtor and I owed you money and you sued me for that money, it is quite unlikely I will do business with you in the future, because no one likes somebody who would actually sue them in court. And so it would actually be mutually beneficial if you would be able to negotiate something with your debtor for future business, where they agree to, both companies agree to continue doing business with each other, and the terms actually set out. And that is actually good for you, for posterity, for long-term earnings for the company. And so these are ways or things that you can actually include into any settlement negotiation that you have with your debtor, so as to make it beneficial for you as the creditor as well. And then you have the question of, okay, I need to do something about this debt. I need to engage someone. Do I get lawyers or do I get debt collectors? Now, I understand that, yes, I am a lawyer. I am not a debt collector. And so I understand that you might be thinking that this is biased. I will say that I know how debt collectors work. I have worked with debt collectors as well. And the reason I work with debt collectors is because when debt collectors are not able to recover any money, they are not able to take further action, and they have to go to a lawyer at the end of the day. And so while debt collectors might seem cheap at first, they actually usually end up being more expensive. Now, this is for two reasons. Firstly, it's because they would take a percentage of the recovery. They would say, okay, you don't pay me first, whatever I recover, I take X amount. See, that's the thing, you never get that with a lawyer because lawyers don't charge contingency or conditional fees. We are not allowed to do that. And so the fees that you are being charged is what you do get. But more importantly, what is a very big issue for me here is this, that when the debt is not able to be collected anyway, the debt collector still has to engage lawyers, and the lawyers will still have to be gotten up to speed. And so when the lawyers have to be gotten up to speed, the fees have to be paid for that as well. And so you're actually ending up paying double. And so it would be always better to go to a lawyer and negotiate it all the way from the front. If I wanted you to issue a letter, if I wanted you to try to demand for the debt to be paid before we file a suit, how much would that cost? And then if the debt is not paid, how much would that cost for me to engage you to file a suit? And that usually ends up to be cheaper and thus more beneficial for you, the creditor company. All right, so this is for existing debt, and there's a lot more that needs to be covered really, and this is just a scheme, but I'm hoping that we are able to see from here that action needs to be taken as soon as possible, and there are many ways of getting around it as opposed to just, you know, going down hard on the debtor, because that really ends up nowhere. What about future debts, future engagements that you have with other suppliers, whether you are supplying your goods or your services? All right, we want to ensure that bad debts don't occur in the future, right? That you don't have to write any of these debts off. We want to ensure that recovery is as close to 100% as possible, and we want to ensure that default is as minimum as possible. So the first thing that you want to look into for your future engagements is to include or incorporate important contractual terms. The kind of the important contractual terms that you want to be looking at incorporating. Firstly, I already mentioned earlier, interest rate for late payment. Steps have to be taken even at negotiation stage to envisage that there would be a default. Many times I find a lot of companies, they get into a contract, they enter into a contract, and then when things go bad, and then you look at the contract, wow, why is it drafted like that? Oh, you know, back then, because we never thought this would happen. Or because back then, the agreement, it was just a handshake. Back then, the agreement, you know, things were very good. The relationship was very good between us. So we never thought this would happen. So we just simply signed a contract, or maybe didn't even sign a contract at all. But actually, it's very important that the parties now envisage a default in payment and then make provisions for that. Because when that does happen, and it does happen, I will tell you, it is important that you have the term in the contract to fall back on to. Now, what kind of terms are we looking at? We are looking at interest rates for late payment. You want to ensure that you have sufficient proof of indebtedness. So you could have terms that state that if there is an invoice or a statement of account, that would be conclusive proof of the debt that is owed by the debtor, because you do not want the debtor later on to dispute whatever invoice that you have issued to them, if they have, especially when they have already signed a contract that says that they accept it once the statement of accounts is issued. So that's the proof of indebtedness kind of clause. And then we want to have another one that talks about the time frame for a dispute. So if you send them an invoice, and if they don't agree with anything that is on the invoice, to make sure that they raise any disputes with you within 14 days, for instance. See, that's very important, because assuming you do go to court and they don't do anything about it, you can prove that they didn't do anything about it. Even if later on they do dispute it, you will say, well, your time is up, I'm sorry. You had 14 days, you didn't do so. This would ensure that you would be able to secure your debt later on, because I have dealt with so many cases where they do not have such clauses, and then you have actual legitimate invoices being issued, and then the debtor doesn't pay, goes to court and says, please prove that I owe you this amount. please prove that the amount stated here in the invoice is legitimate. And then if you are not able to show proper documentation to prove that, the claim is actually lost. And so it's actually very unfortunate for companies that get into that situation, and there are ways to avoid it. And the last kind of contractual term I would recommend to be included would be where you have waivers of debt, waivers of interest and things like that, for that to be made in writing. Because a lot of debtors would always argue and say that you are no longer entitled to this because you have waived your right to claim it. You're not entitled to the interest because you have waived your right to claim it. You sat on it too long. You never filed a claim for 6 years. You only filed it in the 5th year. You are no longer entitled to that. You want to be able to say, no, I never waived my right to claim it against you, because if I had done so, I would have done so in writing. And you want to be able to include that in your contract to ensure that all parties agree that any waiver would have to be made in writing, and that would protect you as the creditor. Moving on, to avoid future bad debts, you want to ensure that you get proper information from your counterparty, meaning from your debtor or your future possible debtor. We find a lot of cases where companies come, okay, I have this debt, this company owes me money. But then when you try to ask further information about how you can contact this company, so on and so forth, they don't have anything to show you, because back when the contract was entered into, the company was too eager to seal the deal. And so no proper due diligence, no proper checks are carried out. And so that becomes a downfall or a pitfall, because it allows the debtor to literally disappear. And we have seen that happen, all right? And so you want information, things like full name, you want identification, IC numbers. If it is a director that is signing, are you sure they are the director? Background checks are important, all right? Because we also get situations where somebody signs and it says director, but then after that, the claim comes and then they say, oh, actually, I was never a director in the company. So how can you say that I actually, so maybe the contract is void in toto. So, you know, it becomes another hurdle that you have to jump over, and you try to avoid that. You then also want to get, say, things like residential address and contact details of as many people as you can who are in power in the company. In the event one person disappears, you are able to go after a few others. And the last information that is very crucial that you must get, if possible, is bank account details. Now, I know it sounds weird. I know it sounds, you might be thinking, if I'm going to get into a contract, why it will be so weird for me to be asking for the other side's bank account details? This is very important, because in the event you do have a debt and you do have a judgment, we have what we call garnishee proceedings, and this is one of the easiest or most straightforward ways of enforcing that debt. And you do so by going after the money in the bank account. So a lot of people don't know this. A lot of people don't see the need to ask for this information. I would encourage you to always ask, or if, let's say, any transfers are made by your debtor to your company via bank transfer, and today it's very common, right? IBG or instant transfer. Take note of that transfer, take note of the bank account that is coming in from, and you need to save that information, because that's going to come in handy later on. The last thing that you want to do is to make sure you have security when you do enter into a contract. What kind of security works? Bank guarantees could work. I'm sure I don't have to explain that. That is where if that does become due, the bank guarantees that they will pay out that amount, or at least up to a certain limit. Personal guarantee is also good. Directors are not liable. So you might be thinking, I am dealing with the director. The director would be personally liable because it's a small company, but as long as it's a Sendirian Berhad, you cannot go after the director personally, and that is the law. And so because of that, we would usually encourage our clients to ensure that they obtain personal guarantees from the director to ensure that in the event of a default, that the director would also be personally liable. What we often get is the director hiding behind the company. They clear out the company. They don't care if the company is wound up, because all of the money and all of the assets have already been transferred out. And so you cannot chase after those amounts. And so that becomes very tricky, not impossible, but very tricky for you to then recover that debt. And so these are some ways that you want to definitely take into account and to take note of in order to prevent bad debts from happening. If you do all these things, I assure you, of course, provided that the documentation and all that is in order, I assure you that the debt recovery process would be cut short by a very, very long time. Trials these days, if you were to file something in court, it would take up to maybe 9 months to a year and a half for your case to be disposed of, especially if it goes to trial. This can actually be cut short, say to half a year, 3 to 6 months, if all your documentation is in order, you have all of the necessary details, and then you are no longer throwing good money after bad. So because of time, I'm going to stop here. Thank you guys so much for this. I hope that you are able to understand a little bit about how, as a company, you would be able to firstly recover your existing debt, and also to prevent your company from having too long a list of bad debts in the future. Thank you.
All right, thank you very much, Mr. Kenneth, for that wonderful sharing. Let's all thank him with the round of applause reaction. All right, so Mr. Kenneth, just to elaborate on what you have said, or the things I found very interesting. You said this, a debt is useless unless until and unless it can be recovered, which was very interesting. And I realized you told us about the typical approaches to debt recovery, which is reactive, adversarial, and mechanical, and we shouldn't be doing that. You also said this, that the winding up process has been made longer from 21 days to 6 months now. So when you were talking about how to recover in existing debts, the first point you shared was do not wait, although you have 6 years, start immediately. And surprisingly, you also said negotiate, not litigate, although you're a lawyer.
Yes.
And I think this was the most interesting, lawyers or debt collectors. So I was wondering, and I wanted to ask that question, and you answered it, get lawyers. Yeah. All right, so you also shared how to avoid future bad debts. You said to include important contractual terms, for example, interest rates for late payments and waivers for debts and interest. You also said get proper information from your counterparty. And most importantly, you also said make sure you have security, for example, like bank guarantees or personal guarantees. So very wonderful sharing. Thank you for that. I think we have a question from Veronica. All right. This is a question on point of payment / invoicing. What if a supplier is very late, few years delay in issuing invoice, acceptance, acknowledgement of service delivery, and ask for payment service rendered? Is it also 6 years limitation? Can the payer reject the invoice, as it could be impossible for the company to verify acceptance or delivery of services due to person in charge resigning?
Yes, I think that is a very good question because it's a very practical issue. We deal with this all the time. This is a very common problem. And so we do get a situation where services or goods were already delivered or rendered, and then there is then the invoice that comes many years later. So the question becomes, when does that debt actually accrue? When does it start being payable? Now, the answer to this, unfortunately, is not totally strict. Whether a good thing or a bad thing, depending on which side you're on. It could be argued that the debt was accrued or had to be paid from the moment the service or the good was delivered or rendered. It could also be argued that it is only from the point of invoicing, because that is when you know how much needs to be paid. All right. The cases have gone both ways, but what I would say in response to your question, Veronica, is that you are able, as the one who has to pay, right? I take it that you are the one because your question is whether the payer can reject the invoice. I think the payer is entitled to get the supplier or the seller to prove that the invoice is payable. You are entitled to ask not only for the invoice, you are entitled to obtain sufficient documentation. It could be correspondence, it could be emails, it could be letters, delivery orders, sales orders, purchase orders, installation order, or any of these acknowledgement and so on and so forth. But I will also say that you are not able to hide behind an employee or person in charge having left the company to absolve you, the company, from having to pay that debt. Once that debt is due and owing by the company, unfortunately, that survives and it's notwithstanding the person in charge leaving or resigning. I hope that answers your question, Veronica.
Right, thank you, Mr. Kenneth. We have time for one more question, if anyone has any questions. If not, I'll be asking one very interesting question. All right, so we will give the audience about 10 seconds if you want to ask your question. All right. Okay, I guess I'll be asking my question then. Mr. Kenneth, I'm very curious about this. Apart from this debt recovery training, what other trainings is important for companies if they want to recover debts and minimize bad debts in the future?
Thanks for asking this question, Gurmit. When I look at in my experience in dealing with companies and recovering debts, so on and so forth, you realize that there are so many aspects, because you realize that each kind of debt is different, each kind of company is different, the way businesses run are different, which means that mechanisms that are employed would necessarily also be different. And so on this issue of debt recovery itself, I will say that it is not only these topics or these issues that I have shared about. There is actually a lot more. There will be things on negotiation tactics. How do you actually get parties to come to the table? How do you keep records in order to prove that debt? How do you keep records in order to rebut a debt? If, let's say, you are a position, you're in a company where somebody is suing you for that money. There are various methods of debt collection. There are also various options for enforcement of the judgment, you know, whether or not you want to bring the directors to court, whether or not you want to garnish, like I mentioned earlier, whether you want to wind up the company. And so there is a variety of options that are available, and training on this would be required. The other one I would say is also very important is where commercial contracts are drafted, or the skill of drafting commercial contracts. A lot of there was this quote once which I read, which I think is very true. The most expensive legal expense is a cheap lawyer. I read this quote once, and I think it's actually very true, because I know a lot of lawyers who are able to tell you, oh, I can draft your agreement, no problem, very cheap. You just pay me whatever amount of money. Yeah, here you go. This is the agreement, standard. Right, that's the word. That's the word they always use. Standard template. You know, it's very straightforward. It's very simple. And then obviously, you think, well and good. I paid very cheap for this agreement. I get it over and done with, and then I'm back in business. I'm good to go. Except that when something does happen, and then you realize, oh my goodness, this contract is actually lopsided and it does not work to my benefit. And so I think training in terms of drafting of commercial contracts, what should go in. What are the importance of the commercial contracts, important terms, how you want to draft it, how do you negotiate in order to get these terms into the contract, because you cannot wait until the problem occurs. Guys, you cannot wait until the debt is owed. You cannot wait until the dispute arises. You need to envisage that all the way, even when the relationship is still good. And so I think that training on drafting of commercial contracts are very important.
All right, thank you. I think you said something very interesting. The most expensive legal expense is a cheap lawyer.
Yes.
All right, that's very interesting. Okay, so thank you very much, Mr. Kenneth. Now,
Thank you.
let me say this to the audience, right? So you'll be excited to know later on, my colleague Crystal in a short while will be sharing a lot of different or various legal topics that SpeakRight trains in. So stay tuned, hold on to your seats, because in a very short moment, Crystal will be explaining about the legal programs and legal topics that SpeakRight trains in. But before that, let us give Mr. Kenneth a proper round of applause for that wonderful sharing. All right, so let me say this. Let me say this. I want to properly do justice to these two speakers. I would like to share with you what I've learned today. So what have I learned today? From Mr. Xavier, I learned this. MACC has deliberately put in place Section 17A because it knows there are too many business transactions that are tainted by some form of corruption. Number two, companies must proactively put in place adequate procedures to ensure no one in the company engages in corruption. Being prepared, number three, is the most cost-effective method than dealing with the aftermath of an investigation. And number four, being corrupt-free in the long run is good for business. All right. And as for Mr. Kenneth, I learned this. Companies need to start planning and anticipating a default in payment and making the necessary provisions for it. Otherwise, it will be too late by the time the default happens and the company tries to recover the debt owed to it. On that note, I would like to thank the two speakers, and I'd like to pass this control to Crystal to share with every one of you our exciting legal topics that SpeakRight will be training in. All right, over to you, Crystal.
Thank you, Gurmeet. So once again, ladies and gentlemen, thank you so much for being with us from 3 o'clock until now. It's almost 4:27. So just bear with me for another 1-2 minutes because we have something really exciting that we would like to share with you. Like what Gurmeet mentioned just now, SpeakRight has embarked into a training, legal training and services. So here are some of the programs that SpeakRight actually has come up. Just a minute, let me share the screen. I actually have come out total of 11 programs which is related to legal training which we are offering. For those HR folk which is in this room, you may want to pay attention for the training which is you can see a star on it. So the all 11 programs which we are offering, there are potential corporate criminal liabilities, protecting intellectual property and confidentially, legalities of employing foreign workers, down rates by authorities, responding, pursuing legal suit, company vicarious liability, personal data protection, commercial contract, debt recovery, employers' right and obligation to the employees, and last but not least, the consumer protection. But no worries, ladies and gentlemen, because our SpeakRight team, we are going to reach you out by next week in order for us to share with you more information about the legal training that we are going to offer to you. Once again, thank you so much. We would like to take this opportunity on behalf of SpeakRight Consultancy to say thank you so much for your time today. We know tomorrow is a holiday. We'd like to say thank you for all of you and wishing you a very good weekend ahead. Thank you so much.
Those who are celebrating Hari Raya Haji, I would love to actually wish you in this very joyous and meaningful celebration, Selamat Hari Raya Haji. And those who are going back to their village, have a safe journey back to your kampung.